Good afternoon, Mr. Drama. My name is Jackson and I'm a senior solicitor here at Ditchfield & Co. Our firm specialises in wills and estates, commercial transactions and the sale or purchase of property. I myself primarily focus on the wills and estates area. However, I can offer advice in other areas of law within our firm. First of all, I'd like to offer my deepest condolences over the passing of your parents. I understand it is not an easy time or process to go through, and we do thank you for lodging your inquiry with our firm. Now, before I get started, I do have to mention that my advice today can only be general, as I'm unable to act in any capacity as your solicitor before you do sign a cost agreement issued by our firm. Firstly, I will guide you through your rights and professional obligations that must occur when you enter a retainer. Now, before you're able to enter into a retainer with a law firm, the firm must first disclose a cost agreement in which you must sign. Through signing this cost agreement, many professional duties and obligations arise in which you are required by law to follow, including a duty of competence, confidentiality, and loyalty. However, I will explain more of these duties come about further on. Now, a cost agreement is a legal document which outlines information about your legal costs in the matter, including how your costs are to be calculated, an estimate or range of your total legal costs, and also informs you about your rights, like the right to negotiate and the right to dispute your legal costs. Now, the agreement is required to be in writing and must be in clear, plain language to avoid any ambiguity within the document. However, before a client can sign a cost agreement, the firm must be assured that you understand all terms and rights and information relating to these costs. It is for that reason that a legal firm must advise you to seek independent legal advice before entering into any agreement. Now, you will hark correct to the fact that you are allowed to request an itemized bill from your law firm, in which I strongly advise you exercise if you are concerned about any cost issues that are issued by a firm. I also advise you to double check your records just in case there's any signed cost agreements that you may have been issued by the other firm. However, if the other firm has not disclosed any cost agreements to you before engaging in any works on your matter, they are in strict breach of their professional obligations, and I do advise you not to use them. Now, you mentioned that the firm you have hired is charging you a fee of $5,000. Now, just like you have rights associated with legal costs, now so does the law practice. The law does allow a practice to take reasonable security from a client for legal costs. Now, this most common security a solicitor will attain is funds prior to any work being performed, which is put into their trust account. Now, this can also be called a retainer fee. If you have validly entered into a cost agreement with this firm, it may be likely that the monies they are requesting is for this purpose. However, a lawyer does have a duty of competence to a client to endeavour to complete work as soon as reasonably possible and with care. Therefore, it is very unprofessional of them to have not reached out for you prior to this moment for any monies or further instructions on this matter. Now, if this firm does have a valid signed cost agreement with you, then there may be implications upon you hiring our firm for your matter. If you choose to employ our firm, you may be required to immediately pay all legal costs for work performed on your behalf as calculated under the cost agreement. However, if the lawyers have failed in their professional obligations and a cost agreement does exist, you can apply to the court to have that agreement set aside. Now, in relation to your parents' will, we would be very happy to assist you in this matter. However, we do have to make sure all our legal formalities have been completed. For example, a signed cost agreement. After we have completed these requirements, we will have entered into a retainer and we'll be able to assist you with your parents' estate, provided you are the rightful executor. We will require copies of your parents' will and death certificates. We should be able to obtain all these documents from the other law firm. However, as lawyers do have a duty of confidentiality, we must provide them with the signed authorities giving us permission to act on your behalf to recover these documents. However, it is important to note that the firm will not transfer these documents if you are not the rightful executor. However, I'm suggesting you are the rightful executor, considering the firm was happy to take instructions in the first place in this matter. Now, generally, any monies the law firm or yourself contribute to the facilitating of your parents' will should be reimbursed through the estate. However, it is unlikely we will ask for a retainer fee for this matter. However, we may require a retainer fee for other matters that arise here. We will then conduct title searches to identify what assets are in your parents' name and uncover that they are transferable assets. However, we may come across a problem in relation to the duration of time allowed to administer the will. Here in Queensland, the law allows an executor 12 months to start administering the will. You did mention that your parents' death was somewhere near 12 months ago. So as we do our duty of competence, we have to assure that this time restraint is met. Therefore, we may have to apply for the court for an extension of time. This will extend the duration of the matter. The other firm did also owe you this duty, and to not request further instructions within a reasonable time to administer this will is also a breach of their professional obligations. Now, in relation to your parents' shares in Macbeth Proprietary Limited, we are unable to assist in your purchasing your sister's shares in the way you proposed to do. Now, this is because we are unable to deviate in any way which is inconsistent with the instructions of your parents' will. Therefore, if your parents' will does instruct a 50-50 split of shares to you and your sister, we will have to honour this instruction. However, after this has been finalised, we will be able to assist you in purchasing your sister's shares. However, I will explain this process shortly. You are also allowed to continue running the company as you have been until your parents' estate is finalised. Now, once your parents' estate is finalised, any person who owns 50% or more shares in a company is classified a majority shareholder, and a majority shareholder has a significant amount of influence over a company and its direction it runs. Now, it is unclear if your parents' shares actually equate to the full 100% of the company shares. So if it does, making you and your sister both have 50% of the shares. If this is the case, your sister will also be a majority shareholder and have influence over the direction of the company. However, you did mention your sister is okay with you continuing to run the business, so I really don't see this becoming an issue. You also mentioned that your sister has a disability. I am unaware of the degree of your sister's disability, so I'm unclear on her capacity as a beneficiary. Despite her having this disability, this does not bar her from receiving her inheritance. However, when a person receives assets through an inheritance, they do become part of their financial affairs. Now, due to this, a person who does lack the capacity are at much greater risk of misusing or losing their inheritance. Although I suspect this may not be the case with your sister, from what you've informed me, she kind of understands the process of you purchasing her shares, so she must have some concept of all her financial affairs. Nevertheless, a beneficiary who does have a disability, it is sometimes likely that a person who constructed the will, in this case your parents, would have created a testamentary trust. Now, this is the structure within a will that provides for the protection for the beneficiary because a separate trustee holds the trust assets for the benefit of that beneficiary, and the beneficiary's specific needs are considered to be as part of the administration of the trust. Now, we would have to see if your parents' will to see if this is the case. Now, you did mention that you believe your parents' names are on the title of the property in which the company is located. After initial checks are done, we would have to see how this has been left in the will, and if it is a 50-50 split with your sister. It is likely that you and your sister will become tenants in common on this property, each owning a 50% share, which you can do what you want with. Therefore, we may also be able to assist you in becoming the sole owner by paying your sister the compensation for that property, or for her share of the property. But this has to be all done after finalising the estate. But I will need to gather further instructions from you on this matter if you want to continue with that. Now, like mentioned above, we would be able to assist you in the purchase of your sister's shares. It just cannot occur in the matter in which you have instructed. Now, this will be a commercial matter and will include an independent evaluation of your sister's shares. Therefore, despite your sister being agreeable and happy with that $500,000 you offered, it will still have to go through a process to make sure any payment is fair and reasonable to both parties. Now, it is important to mention here that when we enter a retainer, we create a fiduciary relationship, which installs a relationship of trust and confidence. Therefore, it is imperative that we do not act in any manner where a conflict of interest may arise. Now, acting for two clients with adverse interests, like you and your sister and you purchasing her shares off her, this is a conflict of interest. However, the law does allow us to act in this matter so long as both clients, in this case you and your sister, are aware and both give informed consent for us to act. However, here at Ditchfield & Co., we do employ our own company policy to make sure we best serve the interest of our clients. Our policy is firm on acting for more than one client in the same manner, unless that other party is a previous client of the firm, in which case informed consent must be given. Therefore, as your sister is not a previous client to our firm, we will just not be able to assist her in this matter, and she will be required to seek independent legal advice. Now lastly, you mentioned that you would like to get these matters sorted in about 3 weeks. Unfortunately, this is just an insignificant amount of time to complete these above matters, especially considering we have not even entered into a retainer yet. However, we do have a duty of competence to you, so we will endeavour to complete these matters as soon as reasonably possible, so long as we can also provide the best for you. I also respect you offering us $5,000 to complete these matters. Currently, as no cost agreements have been signed, we will not request any monies nor accept any monies into our trust account until an agreement has been signed and costs have been outlined. I understand all this information can be a bit overwhelming, so I will provide you with a brief summary of what has been discussed. So firstly, please check your records to see if any invoice or cost agreement has been issued to you by the other firm. If you would like to retain our services for this matter, we will require a signed cost agreement and authorities to allow us to speak on your behalf to the other firm. This will also allow the firm to transfer any documents relating to your parents' estate to our firm. When we administer your parents' estate, it will have to be done per the instructions of the will, as we're not able to amend or deviate from this. We will then be able to assist you in the purchase of your sister's shares. However, we will have to make sure all purchase price is fair and reasonable to both the parties. Your sister will also have to find independent legal advice, as our firm policy does not allow us to act for 2 clients in the same matter. I will also gather instruction from you regarding the property in which the company is located, and if you'd like to be the sole 100% owner of the property by paying your sister out for her share. Obviously, bear in mind this all can only happen after your parents' estate has been finalised. Now, I do hope this all makes sense. However, I will be sending an email to you highlighting all these points that I've discussed today. Please, if you have any questions, do not hesitate to contact me. I do look forward to hearing from you and possibly helping you with these matters. Thank you very much.